Ready, start. Two of them refer to creditors' interests and how best to deal with recovery of outstanding loans and advances made by them on the one hand, whereas the Sikh Industrial Companies within bracket special provisions bracket close Act 1985 on the other hand deals with certain debtors which are Sikh industrial companies and whether such double inverted comma debtors double inverted comma close having become double inverted comma Sikh double inverted comma close are to be rehabilitated. The question, therefore, is whether the public interest in recovering debts due to banks and financial institutions is to give way to the public interest in rehabilitation of Sikh industrial companies, regard being had to the present economic scenario in the country as reflected in parliamentary legislation. While this act had worked for a period of about 7 years, the Recovery of Debts Due to Banks and Financial Institutions Act 1993 was brought into force pursuant to various committee reports. The Recovery of Debts Due to Banks and Financial Institutions Act 1993 took away the jurisdiction of the courts and vested this jurisdiction in tribunals established by the Act so as to ensure speedy recovery of debts due to the banks and financial institutions mentioned therein. This act also included one appeal to the appellate tribunal and transfer of all suits or other proceedings pending before any court to tribunals set up under the Act. Act contained a non-obstante clause in section 34 stating that its provisions will have effect notwithstanding anything inconsistent contained in any other law for the time being in force or in any instrument having effect by virtue of any other law. In the year 2000, this act was amended so as to incorporate a new subsection within bracket 2 in section 34 together with a saving provision in subsection within bracket 1. It is of some interest to note that this act was to be in addition to and not in derogation of various financial corporation acts and the Sikh Industrial Companies within bracket special provisions bracket close Act 1985. Clearly, therefore, the object of the 2000 amendment to the Recovery of Debts Due to Banks and Financial Institutions Act 1993 was to make the Sikh Industrial Companies within bracket special provisions bracket close Act 1985 prevail over it. Regard being had to the poor working of the Recovery of Debts Due to Banks and Financial Institutions Act 1993, the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002 was brought into force in the year 2002. This 2002 Act was brought into force as a result of two committee reports which opined that recovery of debts due to banks and financial institutions was not moving as speedily as expected and that therefore certain other measures would have to be put in place in order that these banks and financial institutions would better be able to recover debts owing to them. The double inverted comma pivotal double inverted comma close provision, namely section 13 of the said act, makes it clear that banks and financial institutions would now no longer have to wait for a tribunal judgment under the Recovery of Debts Due to Banks and Financial Institutions Act 1993.